welcome everyone. My name is Tedrick Housh, and I am the leader of our cybersecurity and data privacy group, and I'm here along with Ali Bass, who's in our group as well. And we are going to be talking with Larry Kinkaid at BARR Advisory, who's the manager of the cybersecurity consulting group there. And we do view this as a conversation, so if you have questions or want to put things in the chat, we'll try to consider those as we go, if not at the end of the presentation. But the reason this came about is that Larry and I and Ali oftentimes end up talking to one another because clients have two different issues or needs. One is, how do I get my system so that it is protected and I've configured it in the best way for security purposes? And then second, how do I deal with all of the privacy issues that revolve around these new laws and everything related to our data? And so it reminds me of when I was a younger kid, they had a pizza place where I live called Shakey's. And Shakey's had these funny little signs within each of their restaurants. And one of them said, we have a deal with the bank. We don't take checks and they don't make pizza. And so oftentimes we think of these worlds of security and privacy as separate and apart. And our goal today is in our conversation and discussion with you and in our presentation is to get you to understand the need for collaboration between these two separate but both data related instances. So our goal is to explore the need and importance of this collaboration and talk about different ways to achieve it. And so rather than hear me drone on and on, I thought I'd start with Larry. And Larry, can you just provide us with a backdrop of what it is BARR Advisory does and how you approach the security side of this equation?
Definitely. So yeah, Larry Kinkaid, BARR Advisory. We provide vCISO services, and that really kind of encompasses the whole mind map. If you Google CISO mind map, you should find a couple of them. But the idea being that it's a mile wide and an inch deep in regards to everything that security can touch. What we try to do is position ourselves within the sales cycle specifically. So we'll talk a little bit about it, but your SOC 2, your ISOs, your NIST, those are compliance frameworks, and compliance without security is often a shadow box. Um, and security without compliance we look at as chaos. So that's what we try to security and compliance being an element of trust or a way to talk about one another. We rely on those things in order to demonstrate the security programs and really boast about what we're able to get accomplished, and then use those things to reduce friction with various stakeholders. Customers is the typical one. It could also be cyber liability insurance premiums. We really try to think of everything and anything that implicates and would involve security, and that's naturally where privacy comes into play. Kind of as I talked about before, if I continue to pull on the thread here, SOC 2, NIST, and ISO, they really don't have any federal or law-driven requirements. It used to be more of an optional thing, maybe a decade ago, and today's day and age, they're more table stakes in order to have the right conversations and interact with the right, I guess, customers as vendors. But I do challenge that a little bit. I wouldn't say that I wouldn't need any legal help in this regard because now more often than not, I see these included within contracts. So there'll be a requirement of a SOC 2 or SOC 2 equivalent, or it'll say that that they'll throw in the right to audit or something. I'd much rather do one of these things under my own dime, within my own control, with my own interpretation, than managing a right to audit or the liability that could entail of not following some kind of requirement. So another thing too, Tedrick, I know we've talked about this, is the information security writers as well. And not so much to the control level, because you'll see that every once in a while. Oh, you have backups that are managed, that are kept at cold and offsite facilities. Well, in the cloud, that's not necessarily how I talk about it. So how about we just talk about the redundancy element and your expectations as far as SLAs go, instead of kind of pushing us in that regard. So that's when I would definitely pull in legal representation, because I definitely don't feel comfortable redlining a contract to the degree that I know that a customer and their legal team are going to be signing it. So that's part of the collaboration element, at least in regards to those security models at the top. is that I'm going to, throw in suggestions. We're going to work together, but I definitely need someone with a legally driven background to assist me with those kinds of things. So while the Venn diagram, I'm going to refer to often to a Venn diagram. Most of this is owned or managed within the shared responsibility of cybersecurity or infosec. There's still the legal element that I definitely lean very heavily on for Tedrick and his team.
Yeah, one thing I'd add or make a point to, Larry, is with respect to the legal obligations within the just security realm. I think that's changing. It's a slow creep, but if you look at Graham Leach Bliley or the New York financial security law, I know that if you were not to have multi-factor authentication, or if you were to have passwords in text form, that would violate at least the basic requirements of some of these laws. But for the most part, regulators and legislators have not tried to tread upon the expertise that the folks in this cybersecurity group would have. The second item here on our slide, Ali, deals with the laws that regulate privacy and therefore have a connection to security as well. Do you want to just give us an overview of what it is we're looking at in that regard?
Yeah, absolutely. So there are currently 20 states with comprehensive consumer privacy laws. And in this context, comprehensive means that the law includes detailed customer or individual rights as well as business obligations. And those individual rights address the collection, use, and disclosure of personal information. And so there's a couple of notable state laws, all for different reasons, that we'll talk about: California, Virginia, and Colorado. So California was the first state to pass a comprehensive state privacy law. And after its enactment, many states passed their own comprehensive laws, making up those 20 states that we see today. And California, we highlight because it takes an expansive view of what doing business in the state means. So in California, if you've got an annual revenue of 25 million, process the data of at least 100,000 consumers, or receive at least 50% of your revenue from the selling or sharing of data, then your business would be subject to that California law. And it's also important to note that California provides a private right of action related to security breaches, but we'll talk a little bit more about that later. Virginia was actually the second state to enact a comprehensive consumer privacy law. And that law requires companies to conduct data protection assessments in order to process data for targeted ads and sales. And then finally, Colorado excludes from its law information that's been de-identified or publicly available information. And unlike California and Virginia, Colorado also applies to nonprofits.
So from an overview perspective, one point I think most individuals on this webinar who are attending already know, but what's interesting about data privacy regulation in the US is if you have a data breach and personal information or personal data is released or accessed by someone who shouldn't, the law with respect to notice that applies, and all 50 states have laws about this, the law that applies is the one in which the data subject resides. So if you have a resident in Florida, they may need their notice within 30 days of the triggering event. And in other states, it may just say as soon as possible or immediately or promptly. And in all of, since we don't have one federal law regarding all of this, there are also additional things that differ between the states. For example, in some states, you're permitted to engage in what's called a risk of harm analysis, where if you come to the conclusion that, well, the data was out there for a little bit, we found it, the person we sent the email to immediately gave it back to us, they provided us an affidavit that they didn't do anything with it. In some states, you can say the risk of harm was not so much that we're going to call this a breach, so notice isn't required. In other states, or perhaps with, say, HIPAA and healthcare, that may not work. So there's with a sort of patchwork system of regulation and privacy and security, as opposed to, say, the European-centric model. Those are additional considerations to have. So we have a bunch of letters here of alphabet soup on the bottom of this slide. And Larry, do you want to walk us through who those folks are?
Oh, the old alphabet soup C-suite action going on right there. Um, I feel like I'm being quizzed. We got the chief financial officer, we got the chief information officer, chief information security officer, data protection officer, and of course, general counsel. Oh, Tedrick, I think it was GameCube. Maybe that was the joke I made the other day. Um, Anyways, so, there's uh, acronyms galore, and especially between cybersecurity and I guess more of the legal aspect. But I think kind of talking bringing back up to the mind map is that there's just a plethora of different activities that encompass security, and really what we want to do is try to bring harmony to everybody's concerns. So the chief financial officer, they're I mean, their thing is about fraud and the material aspects of the financial statements, whether it's public or private. So they want to ensure that the general ledger is stays intact. The CISO, here's these risks, here's what keeps them up at night, and tries to apply segregation of duties, logical access, and other controls. The CIO, again, still within the same realm, but of course their concerns are going to be a little different than the CFOs or the DPOs. And of course, as we're talking about today, that relationship between security and privacy, the DPO and the CISO, and then I guess the general counsel as well, come into play. And I think privacy is where the that Venn diagram, or that the shared responsibilities that I alluded to before, kind of even out a little more. And I kind of talking through SOC 2 and ISO specifically, scoping is a really big part of what we do. And if you don't accurately scope things, you kind of just apply a wide brush and apply maybe too stringent controls on the whole environment, as opposed to focusing on the right thing. So SOC 2 specifically is very product or service driven. So, customer commitments is typically what we say. What are the customer commitments that you say that you are committing to? Versus ISO. ISO is entity based. So that also includes, operational and employee data and IP as well, in addition to your customer data. So within privacy, and Tedrick, this is what I definitely rely upon you for, is I know PII can be defined a little differently state by state. There's no federal definition. So, what laws apply where? How can we scope this and simplify that scope so we're not just applying it as a one-off or as a broad stroke throughout the environment as well. So um, very much rely on your expertise there.
Well, and one thing I'd sort of back up and ask is, if BARR Advisory is dealing with a client and they're going to provide them with a review of the security measures and processes they have in place. You mentioned that there could be a SOC 2, which is more of an accounting-like high review, I think, of the processes that exist. And then you can get more detailed with NIST, which is the National Institute of Scientific
Standards and technology.
Yeah, science and technology, which is a more specific, very detailed chart-like going through of all of the operating procedures. And ISO sort of, I think, a bit of a mix between the two, which is a institute that provides different ways that you can get sort of the gold star of approval and have that in place. So whichever one of those that you're going to a client about, who primarily do you find are the decision makers among these alphabet soup folks?
Ooh. Actually, in regards to the security models above, I trying to think. I mean, it varies, I guess, is the cheap answer here. But honestly, I really look to customer expectations on those, because, in some industries, especially here based in the States, SOC 2 Type 2 is the gold standard. ISO tends to be more internationally, but I think it's gaining more and more popularity here in the States as well. Um, but yeah, I mean, it is a budget decision at the end of the day in regards to, certifying or reporting against one or the other. So it I do find that we start with one and end up getting the other anyways. There's a lot of crossover between the two, and they really complement each other because they don't cover the same things. Their scoping is a little different. And to your point, SOC is sponsored, or sponsored is not the right word, but managed or controlled uh, by the AICPA. So SOC 1 is more of the financially driven report about the materiality of the financials. So CFO would be the one that would want that, but it's also the CFO of your customer that would want you to have it if you do manage the in and out of cash, or the materiality of I guess the bunnies.
Mhm.
But SOC 2 Type 2, or SOC 2 Type 1 even as well, is the ICPA's interpretation of COBIT and the trust services criteria. So not to get too into the weeds on the technicalities of the frameworks themselves, but there's kind of in summary, there's like purpose behind each and every one of them, and really the driver for me is the expectations of the customer.
So in my experience, the security aspect of this is typically, and it depends on the maturity of the organization and the size of the organization, right? So some organizations may have all of their IT done, particularly small ones, by their outside IT firm. So Bill
Mhm.
or Chuck or whoever it is the person who handles all that. And that's perfectly fine, except you want to make sure if you're going to be testing, which is good, if you're going to look at the robustness of your security system, you're going to want to allow for this interaction with the different sort of auditing aspects of this. For the privacy, so you will be dealing probably, if you were a more mature organization, with the CISO, and then above that would be the CIO, who's concerned with other aspects of the technology, just not security. And then the CFO will always have to write the check. It's a little more
Yep.
complicated or different on the privacy side. Many times we find privacy is housed in the general counsel's office as sort of part of the legal aspect of things. In other organizations, it's sort of floating on its own, or it's part of the CIO's responsibility and deemed sort of part of the technical protections and aspects of concerns. And then with those organizations that are large enough or sophisticated enough to have a DPO, a data protection officer, or data privacy officer, that is that person can rest anywhere in the organizational chart, but it shows that the organization has really dedicated themselves to privacy. And I'll back up in an even broader picture to say that with respect to at least publicly held corporations, there's an expectation from the SEC that the board of directors have at least an eye on what's going on with respect to protection from data breaches and cyber attacks, and a plan, an incident response plan in place for responding to those kinds of things. And if those are not present, the company may be subject to a shareholder derivative suit or some other kind of claim by, say, a victim of a data breach, that the company had not basically done the reasonable steps to protect itself. So that's why I think the SEC would recommend, and sort of best practices is evolving into either the audit committee or a special committee of the board here, at least quarterly, from either the CISO or the person responsible for both security and privacy, and understand what the status is of all the various protections and what the main risks and concerns are. And if you do those things, you're sort of ahead of the game and prepared for the time that a crisis may come, and knock on wood, hopefully it won't, but many companies have already been breached and don't know it, to quote the folks from the federal CISA. So one of the things that I believe you said, Ali, was that California was the first. No, the wrong knowledge check. So when you talk about who's responsible for cybersecurity and compliance, and this is probably, hopefully, like one of those driver's license tests where you know the answer and it's pretty easy. But we know that everyone in the company is ultimately responsible, from the person who does not click on the phishing email to the CISO who provides the quarterly reports to the board or the audit committee. So those of you who are seeking CPE, everyone doesn't have to answer this, but for those of you on the security side who are seeking CPE, you need to answer this question. And once you voted, we'll see that, all of you, it doesn't matter if you're right or wrong for CPE purposes, by the way, it's just to make sure you're there. And I'm sure the folks who said CIO and CISO have a very good reason why that would be the right answer, because they are probably primarily responsible. So with that said, let's keep moving on. And there we go. So I want to talk a little bit more about the specific compliance issues that companies face when they're dealing with security and privacy issues. And I think they kind of divide up into these two buckets. And the left one is, I think, primarily security, and the right one is primarily privacy, although they definitely have a Venn diagram aspect to them. So Larry, what's keeping you and other security folks up at night right now?
That's a valid question. I mean, I think AI, which I know we talk about a little later, is definitely the flavor of the month in regards to what the security industry is touting and running around with. But ransomware, phishing, those are definitely the big ones because are the there's the technical vulnerabilities and the secure code development elements of things that you want to do within DevSecOps. But it's always the user that's looked at as the weakest link in regards to getting into a breach, right? So from there, there's it's very rarely that one vulnerability or one exploit, one phishing email is where the whole exploit takes place or the whole breach. It's always a pivot in between the environment. So someone might get like compromised credentials and get to a Microsoft Teams. Oh, and the public Teams, there's some access codes or SSH keys to different environments within there because they're using shared credentials, and then they pivot and pivot and pivot until the domain is compromised, domain admin credentials are found, right? So it's never just one thing, it's always a pivot and an acceleration between the environment of different exploits and different vulnerabilities within. So that's why the I guess the prime entry point for anybody is never the outside moat, if you will, as I've always referred to it as, like the network pen test is looking for. It's typically a phishing or ransomware, I guess, is another way. So but yeah, on our side, it's definitely that. And then, of course, the interesting thing is, and again, where I would pull in your expertise is, we security used to be more of a FUD uh, scare tactic, fear, uncertainty, and doubt. We always point to Target or Home Depot in regards to PCI or this company, that's hitting headlines, Solar Winds and Heartbleed, right? It's this headline and fear, uncertainty, and doubt. But we all know that we become desensitized to those things, so those aren't as nearly as effective as they used to be. And then, of course, you point to reputational risks and other things, and maybe just time to remediate as a scare tactic in general. But that's where we really do rely upon, hey, what are the fines? What is the financial liability of something like this happening, especially if it hits the properly scoped data that we talked about before.
Yeah, and just to sort of change subjects regarding sort of these concerns, the most recent giant one that I think we've heard of is CrowdStrike, and that's where everyone was stranded in airports primarily, and then all kinds of other businesses had trouble communicating. Do you have some general overview as to what happened there, or do we have better insight now that some time has passed?
Ooh, that's a good question because I mean, there's a lot of, I think, I wouldn't say misinformation, but maybe just like there's narratives that really focus on one element versus the other, when I think it was kind of a perfect storm. As I talked about before, it's never just one thing that failed. There's multiple levels of failure in the CrowdStrike. And I think specifically CrowdStrike was one of the first people to kind of admit that. I think they did a really good job. There's a couple of missteps, I believe, but I think generally they did do a good job of responding and being transparent about, hey, this is where we are responsible within this whole mess, and here's what we're doing about it. Then there is the element of Microsoft, and I know many people are thinking like, well, we can't have too many things on one operating system. But I don't know. I mean, that's just the nature of the beast today. It's either Macs or Microsoft in regards to what your endpoints are. But Microsoft, I do believe, has some culpability in the whole what transpired. In addition to, I guess what would they refer to it as, the boot scripts, because of where it was within the operating system. But again, I just double down on the fact that it was multiple levels of failure and that it was a perfect storm in this case.
Yeah, and I don't think that's different than most of the events that we see. And what I like to keep in mind is, in most of these instances, as much as there's finger pointing, I remember with the OPM breach with the Office of Public Management, and Equifax, that it was blamed, I think, on a guy named Max who failed to do the Tuesday patches. I mean, there's always someone to blame or multiple fingers to be pointed. But what we forget is the ultimate culprit in all of these things are the threat actors or the bad guys. And they're everywhere and they're working hard. And phishing and the human element is the most, obvious place for a threat actor to go to get inside a system or to move horizontally within the system. And I'll also say that in my experience, we've seen a large increase in ransomware over the past 4 or 5 years. And if you haven't experienced it, I'm glad. But if you have, one of your employees will be sitting there and a screen will come up with a skull and crossbones, and it will say, we have grabbed your data and encrypted it. And if you want a key to get your data back, you need to pay us X amount of Bitcoin or whichever cryptocurrency they may use. Some are more hard to trace than others. And typically what a company does is talk to their insurance company, who usually has folks who are used to negotiating with these particular threat actors, which tend to come from Russia and that part of the world. And insurance companies do tend to cover and pay these ransom amounts. Now, they will negotiate them and they will try to solve them. But another aspect of this is talking, say, to the FBI or Secret Service, because they may well have one of those decryption keys from just having followed and worked and traced these folks. So there's this whole process that kicks into gear that, again, it's an important part of having an incident response plan, because with those things in place, you know who you're going to contact, you know what you've planned ahead for, and the process won't be quite as difficult. But it is, that's just a couple of the attack vectors that we see.
Yeah.
Go ahead.
Something interesting you said, and it's something really interesting, as I think it's really important to kind of distinguish, is that I think a lot of people put a lot of weight on, the frameworks for demonstrating their security, but it's less about, hey, I'm ISO certified, I have a SOC 2 report, I'm certified your data's safe with me, and more about that you have the proper processes in place. You have preventative controls and they're documented. You have the detective controls. Not only that, but you have the ability to recover and remediate through incident response, business continuity, disaster recovery. So it's more of the demonstration that you are prepared to handle these things, as opposed to just like dealing with them ad hoc and in a reactive manner. So it's a proactive kind of like method more than anything.
And then on the other side of things, so you would face, some of the just rebuilding of your system and potential liabilities, just resulting from maybe the drop in the stock price if you've had a big issue, with the ones that come from regulators and litigation. And so, Allie, I'm going to have you talk about sort of legislative regulation in a moment, but I will mention that litigation is probably as much a curb factor or a determinative behavior factor as regulation, because while someone may pass a law, if you never really see the regulator, then it's a little bit theoretical, as opposed to if there are a bunch of class action suits going around and you are dealing with them, that has much more of a pronounced and immediate effect on your bottom line. So from a litigation perspective, if there is a breach, I already previously mentioned the possibility of derivative suits against the board, or sometimes if it, for example, with Target, it involved a lot of credit card issuing banks having to pay back a lot of credit cards or things that have been charged up, and they wanted that money back from Target. And again, this is back in 2014, so it was sort of the first lesson learned. And nowadays, I'll talk about it a little bit more later, but nowadays we're seeing, these kinds of suits not only come from data breaches, where even in California, you can get a class action data breach and find yourself subject to damages. And that's true in a lot of other states too, if you haven't acted, quote unquote, reasonably to protect the data. But now if you have certain data capturing pixels on your website or other aspects of it, then you're going to find yourself in new class action litigation where you're trying to decide where your data is collected and with whom you share it. So those are all things that are of concern. So by regulation, really what I mean are these state laws that are out there, Allie, and in your introduction, you talked about the 20 that are more comprehensive and the issues associated with California, Virginia, and Colorado. But I didn't know if you had more that you wanted to expand on with respect to any of them. But to me, California comes to mind because it is the sort of it's the big regulator that everyone seems to follow.
Well, one of the things I thought that we could do is we've used a couple acronyms and kind of address things like the GLBA, and I thought it might be helpful to kind of zoom out a little bit, just to make sure that the listeners can kind of follow along. So we'll start with, for example, the sectoral privacy laws. So we have laws like the GLBA, which financial institutions and banks are subject to, and then we have, and that's the Gramm-Leach-Bliley Act, and then we have laws like HIPAA, or the Health Insurance Portability and Accountability Act, which covered healthcare entities are subject to. And then when we get into state privacy laws, you heard Tedrick mention earlier that this kind of patchwork that we have here in the US, where there are some states with privacy laws and some states without. That's where those 20 comprehensive state privacy laws come from. And then in contrast to that, we've got in the EU, there's the GDPR, or the General Data Protection Regulation. So instead of having a kind of patchwork system, there is just one law that EU residents that protects their data. And so I think that might be helpful just to give some perspective generally to how things work in the privacy world.
I know that one thing you're going to hear a lot about in the next year or three, but probably more in the next year, is that a number of these states now make reference to sensitive personal information, which could be race, which could be certain health information. And each state, again, has its own list of what constitutes sensitive personal information. But if you are processing sensitive personal information, and by processing, I mean holding, storing, or doing something with. If you're processing sensitive personal information, a number of these states, including those that are listed here, will expect you to engage in a privacy impact assessment so that you go through a process and create a document where you've looked at what you do to protect that data and who's using it. And if you're using a third party, let's say that you're using Salesforce, and it has sensitive personal information in it, or Workday, which obviously does if it has employee information. More and more of these state regulators are going to say, can we please see your PIA, your privacy impact assessment, that shows what you have done reasonably to protect this information. And it's just starting. And where it really has, if you want examples that are out there on the internet, or if you want to get an idea of what these look like, the federal government has had to do these for quite some time. So if the EPA is going to use Workday, if you Google, you will find the EPA's sort of statement of what their mission is, why they bought this software, what data they collect, the sources of it, and what measures they take to protect it. Now, they don't spill all the beans, just like the SEC doesn't expect companies in their quarterly and other annual reports to spell out all the details of how they protect data, but there should be some summary of the intentions and general actions taken. So you might just stick PIA into the world of acronyms that I think you're going to see more and more of. And that's something that, again, embraces both. There are firms that just will do that, and then it's something that we do. It's something that you're going to find a lot of people do, but it involves a dialogue and conversation and deliverable associated with what is sensitive personal information. And the one good thing that I think is derived from both those kinds of regulatory requirements, to the extent they hit, or really more likely where you've been forced to stare at your own processes and look at it, would be with respect to insurance. And so, Larry, I was going to ask you, how often are you dealing with a client who's trying to respond to either one of their vendors or one of their customers or their insurer, if they're applying for cyber liability insurance, some sort of due diligence questionnaire? And how does that work?
Uh, all day, every day. They never stop. Everybody's got a different flavor to it too. And the nice thing is, again, those frameworks kind of normalize it to a degree because it does, bring and invite like a standard to do things. But everybody, and especially it's very industry dependent, I found as well. Your financial sector is very, very much going to be doing, questionnaires and one of the I guess the popular solutions out there nowadays. But yeah, I mean, that's the way that people are doing it, and there's the questionnaires, there's Sig Light or SIGs that I see quite often as well, in addition to CSA or Cloud Security Alliance Cake. That was Consensus Cloud Assessment Initiative Questionnaire, if another acronym. But again, just normalized questions are the way to go, but some of them are a lot more proprietary. And then another thing that I've seen getting a lot of steam are these automated risk solutions. So just naming a couple just for the sake of context, there's like Security Scorecard, BitSight, Risk Recon, and I think there's a bunch of more out there as well. But the idea is like, oh, you input this domain, and we're going to be able to tell you how risky this particular solution is, which doesn't tell the whole story, but it is a method of determining risk and I guess an effective way. And yeah. So I think to answer your question, there's just it's happening all the time, and really the idea is that we're so fractional in regards to the services that are being provided. You're in this cloud, I'm in that cloud. Here's a SaaS over here. Here's the SaaS over there. There needs to be some kind of due diligence or level of trust to be established between different entities. And the questionnaire was the de facto 10 years ago. It's still around today, but there's other better ways to do it now.
I know that in my experience, when those questionnaires are received, I often get a call on the really tough question because they aren't quite sure what they mean. And so you have to provide it some context with respect to both the relationship between the parties, how it's worded and the like. So, there are all kinds of questions like that where you don't want to, for example, on an insurance application, end up voiding your coverage because you've made a misrepresentation. But oftentimes, it's not very clear at all what is meant. And so you have to decide whether it's better to have a vague ability to point to the vagueness of the question or not. But it can be really difficult with respect to some of these questions. Some of them, I know I have clients who have said, hey, this client of ours, this customer of ours wants to make sure that we're GDPR compliant. And they were just a US-based small, relatively small business entity that engaged in e-commerce. And I said, well, I don't know why they need to know that, but that's really hard to say. You can't just check yes. That's a whole process, particularly if you're dealing with EU data. And I'll just, as an aside, since I mentioned the EU, that's where really data regulation and data privacy started. And it started way back after World War II with the division of the Iron Curtain and those countries that engaged in intense surveillance in Eastern Europe. And when the wall came down and there was just much more of an interest in privacy as a fundamental right, whereas in the US Constitution, it's deemed a penumbra, it's not specifically mentioned. So we have different tensions and different concerns in the US. But the Europeans have passed the General Data Protection Regulation. It's when I mentioned GDPR, you've probably heard of it. It was enacted on May 25th, 2018, and there have been a number of changes. But basically, if you are processing, and remember that term is broad, if you're processing data of a European resident, so that could be a US person who resides in the EU. It's not just by citizenship. If you're processing their data here in the US, then you've crossed country lines, and the Europeans do not deem the US to have adequate security standards because of the sharing that may occur with the US government or through Google or otherwise. So you have to use something called standard contractual clauses or another mechanism where you make some promises and agree to EU jurisdiction in order to process that European information. And I don't know how many of you have to deal with that. The other way that you come under the jurisdiction is if you are offering goods and services or have an enterprise in Europe and say your website says we'll accept payment in euros. and you're selling something specifically to someone in Germany or France, then you also will be deemed covered by that. But when you're covered by that, you're dealing with a much more aggressive regulatory system that can fine you up to 4% of your annual revenue. Now that rarely, if ever, happens. That's based on their antitrust fine scheme, but the Googles and the Metas of the world certainly look at those numbers with some fear. And the last thing I'll say sort of about the regulation aspects of all of this is that the CCPA, the California Consumer Privacy Act, which was amended in 2023 to encompass employees and businesses as covered by it, not just consumers. It has its own agency that's been created, the CPPA, and it will fund itself through the fines that it gathers through its regulatory actions. So California is just like with car emissions, is a place where a lot of this starts and will continue to grow. So California being the big one, I'm going to go to our next knowledge check. And the question is, which state had the first comprehensive consumer privacy law in the US? And again, for those of you seeking CPE, this is mandatory. For the rest of you, it's for your own edification or joy in filling it out. We'll wait a second for the poll results. Good job, everybody. And so moving on, our next, I'm just trying to get past this screen just a sec. There we go. We've talked about these state data breach laws, and I know that Allie, you've mentioned a number of these things. One thing that I thought we'd mention here at the bottom are the exceptions. I mentioned the fact that some states have a risk of harm determination you can make. Some of them have an exception for law enforcement. So if law enforcement tells you not to notify people that there's been a data breach, that's an issue. But this also is, there's this issue of safe harbor in with respect to encrypted data. How does that work, Allie?
Yeah, so safe harbor data would be data that is encrypted or redacted or unreadable or unusable. And this exception kind of highlights the necessity of having both your privacy counsel and your cybersecurity team work together. Because what can happen is if it takes place or there's a breach, your cybersecurity expert will go in and determine what data has been accessed and whether or not the data that was accessed was encrypted or whether a security encryption key had been breached. And then once that determination is made, your counsel can come in and help you determine who should be notified, when, or whether notification is required at all. And I mentioned notification requirements because different states, well, have different requirements, and most, but not all states have a 45-day notification requirement. But the industry standard is actually a 30-day notification requirement. And that's particularly important for companies that have a national presence. So all of that kind of highlights the importance of having a team that works together.
Yeah, and so if some data is encrypted in many states, that doesn't count as personal information. So it's not something that triggers notice. I guess the way I would think about it figuratively is if one of these threat actors engaged in ransomware and they got in and took a bunch of your data and exfiltrated it, and generally what they will do with it is put it on a dark website so that people can get to the data and use it. If it's encrypted, they basically just stolen a safe that they don't have the combination to. And so there's no harm, even if you don't have a risk of harm analysis in many of these states. They'll say, well, if the data was encrypted, you're protected. So you'd say, well, why doesn't everyone just encrypt all of their data all the time in transit, at rest, even all the operational data that you have, whether it's even sensitive or confidential or worrisome or not? And my understanding is that's pretty hard to do from a security perspective, and it's pretty expensive. But Larry, I don't know if you have thoughts on that.
Yep. I mean, a lot of these things are built without that in mind. So then there's a lot of technical debt, as we refer to it as. So, it's pulling and replacing. It's trying to put a basement under a ranch in a way, right? You have to lift up the house and redo it all. So it's not that it can't be done. It definitely can be. And then the other element of the pull and replace is also it's expensive to do those things as well, and it should slow things down because you have to encrypt and then decrypt. Is it going to be decrypted over here and encrypted over there? Where are the keys going to be stored? So now you got to worry about cryptography. And then just to throw another wrench into the whole idea, if you want to really look into it, quantum computing. So that safe that you referred to earlier that's on the dark web, yeah, it's there and it's locked and no one can touch it. But with the idea of quantum computing right around the corner, are they going to be able to crack these encryptions later on? I don't know what the consideration is from a legal standpoint, but that's something that we definitely think about as like, okay, there's all these data breaches with encrypted data that are out there. When is the other shoe going to drop, and when are these safes going to be cracked?
Yeah, so if the technology gets there and these encryptions don't work anymore, suddenly that protection probably goes away as well.
Exactly. That's I don't know if you guys saw recently though. It was definitely more of an Apple press release though. But I guess iMessages is now encrypted to beat the quantum computing element that we've talked about. So quantum computing is there's a definition of like I guess the processing power to be considered quantum. So it is definitely something that is. I mean, it's kind of thrown around, I think, and in conversation without much regard, but there is a definition of it. And then, I mean, people think that's next year, 10 years away at this point.
Yeah, and my only understanding of it, even remotely technical, is that you think of computers as ones and zeros with respect to the not even the machine code or how it works. And I understand with quantum computing, it works so that things are both one and zero at the same time. I'm not
Uh-huh.
quite sure how it works, but that's my
It,
understanding.
it's definitely over my head. It's like I feel like you need to be a mathematician. I do understand the ramifications and what that means down the road, but yeah, no, it's a scary thought and how that's going to affect everything.
Yeah. Well, one thing I'll mention about ransomware, just to make sure we cover different aspects of both security and privacy. If you've had personal information taken as part of a ransomware attack and they're holding the data hostage and saying, pay us a certain amount. And now I think the average is like 3.5 million. They paid 10 million, if you remember the Colonial Pipeline ransomware event that affected the East Coast about 2.5, 3 years ago. But that's the first stage now of ransomware, because you pay to get the decryption key or to get your data returned to you. But then the second part of it is they'll come back, the same threat actors, and say, oh, by the way, we want some more ransom from you to keep us from releasing it to the public. So they'll hold off on that and seek that additional money, which again makes this a scourge upon commerce and generally in our economy. And it's something that we're trying to address. But insuring for it just passes the cost on to everyone all at once. Again, although there have been actions taken against these threat actors, it's a real problem in all aspects of cybercrime. Okay, so a few other specific thoughts that I think most companies need to be thinking about and are vetting and contracting with customers and service providers. And I previously mentioned that oftentimes due diligence questionnaires and other similar requirements of what protections are you going to have or how can we trust you to work with our data is often in a master service agreement, but usually in what's called a data processing addendum, a DPA, in which invariably the lawyers end up and the companies end up talking about indemnity and how each side should be responsible. And oftentimes the person who writes the master service agreement will say something like, we're going to let you use our data, but you're responsible for everything bad that will happen after that. To which the response, if I'm representing the vendor, would be, we're not responsible for stuff you guys do wrong. And so eventually that gets negotiated to sort of a mutual indemnity. You just want to avoid those one-way indemnity provisions either way, if you're on the receiving end of those in negotiating contracts. But, service providers are just like employees, among the weakest links. Again, going back just to the archetypical data breach that we know in 2014 with Target, that occurred through a HVAC vendor that was hacked, and they got in and were able to go to point of sale terminals just through the horizontal movement through the system and get a lot of credit card information. So there are things that you need to do with respect to dealing with both your customers when you're protecting their data and your service providers when you're entrusting them with the data that you need to do. So I don't know if both Larry, you and Allie want to talk about how you kick the tires both as a lawyer and as a cybersecurity professional on those relationships.
So I can speak from the service provider standpoint of like demonstrating that we're good stewards of our customers' data, both from a confidentiality and availability. There's many people may have heard of trust centers or trust pages are becoming really, really popular right now. But that's really kind of the um, center of the due diligence that I'm creating with my clients. And you post, your reports in there, your certifications, as I've talked about before, penetration testing summaries, network diagrams, right? Really, all the due diligence documentation that should be asked for. You prepare it on a silver platter with watermarks and everything else. But then the cool thing is that's been adopted is it also has the sub processors. And you can also subscribe to the sub processor list. So that way you know when those are going in and out. So, not only just using the cybersecurity like frameworks and elements that I was talking about before, but now we're adopting the privacy elements in here as well. And then of course I always ensure that we have I guess a boilerplate like DPA, where talking about the standard contractual clauses, if that's what we're going to be leveraging, and then of course our security controls are documented there as well. They just have to, it's already signed. They just have to sign it. It's our paper. So, anyways, it's kind of just staging everything to a degree to be like everything that we need it to be for our customers, to reduce that friction and really show that we're doing everything that we need to do to be good partners.
And Allie, I assume it's mainly how you go about contracting, but what kinds of things can you do?
Yeah, so in negotiating those contracts, one of the things that you can do is ask for the vendor incident response plan and review that. And so that can be helpful in those instances.
Yeah. And
Well,
what, go ahead, Larry.
oh, love that, because that's something like if I, and it's actually something that does come up quite often, more recently, which is interesting. I feel like, they must be talking to you, Allie, about their due diligence programs. But those are definitely one things that we consider putting out there. And again, we listen to the customer. If we see something come up over and over and over again, okay, let's throw our incident response plan out there in regards and to the rest of our security package. So, good call out.
And one thing, just as an easy sort of gut check for a company or vendor or customer with whom my client's dealing, if you just go to their webpage and see when their privacy policy was last updated, like I said, given that GDPR passed in 2018 and the California law was enacted in 2020 and amended in 2023, and we have new changes with all these other state laws, if you have a privacy policy from 2017, it tells me you really haven't been focused on privacy, and it might be something we need to consider. It may well just be an oversight, and that everything the company, your customer or vendor is doing is up to snuff. They just haven't, redone their privacy policy. But oftentimes it's a little bit of a telltale of something to be considered. And then I think we've talked about it quite a bit with respect to financial and healthcare clients. These are the areas that for a long time have received extra scrutiny and had extra requirements imposed by the folks in these sectors. So anybody who's dealt with a national bank knows that there are certain expectations that are imposed upon you before you're going to be able to work with their data and deal with those things. And it's something you should know. So let's go to our third and final knowledge check. And in the business world, what does AI stand for? Anti-intelligence, artificial intelligence, algorithm intelligence, or accelerated intelligence? So we'll wait for the votes to come in. And again, this is more taking attendance than worrying about how you did, and it's anonymous. Look at that. Perfect score. So one of the things that I included in this in this program that we'll talk about at the very end and allow for questions on is artificial intelligence and its role, because it's a buzzword in almost everything you hear, and automated decision making and the use of algorithms. Right now, in my view, in the commercial world, a lot of where you see it is with respect to chatbots and customer service attempts, but it's going to make its way into auditing and all kinds of other things. So, but before and I sort of already did that, so we can look at that last slide, but these are just a few other things we wanted to mention. So under the FTC, they're looking in regulation at dark patterns where it's in a way misleading what you're saying or doing to gather data or decisions from a consumer. And so, where it's the basic trickery where you are clicking something and not realizing that you're giving permission to more than you thought. One example of this that's been impacted by the FCC is that they have, as of July of this 2025, there's a rule that's going to go in place that if you are seeking to send text messages to a particular consumer, that you can no longer just get permission to send marketing materials from you and all of your affiliates and partners. So these lead generation pages, which is how basically e-commerce works, that were people who were interested in your product or generally in your subject area that might want to be targeted to come to your web page. And to the extent that those folks are gathered on a page and that page gets consent to send it to everybody who's their client for marketing purposes, so the consumer gets a whole bunch of text from a whole bunch of people, and I'm sure you all know what I mean, particularly even in this political time, you're probably getting lots of those. That's going to be, at least with respect to marketing, banned, and that when you get permission, it has to be for one specific seller, and that's it. So you'll see the landscape of e-marketing change. Also, I don't want to go too long on litigation hotbeds, but I'd mentioned these earlier. The CIPA is the California Invasion of Privacy Act, and that one involves those meta pixels or TikTok pixels that gather information about the website visitor before they are able to consent or click on a cookie banner or do anything else. And it sends it off to Meta, or it sends it off to TikTok, so that those people start getting ads targeted to them. So if you went to a website and typed in colon cancer doctors, you might start getting that kind of information. So that's prompted a number of class action litigation. The VPPA, I'll just mention briefly, is the Video Privacy Protection Act. It goes all the way back to Robert Bork. For those of you who might remember, he was put up as a justice for the Supreme Court. And some folks went to Blockbuster Video. Again, I don't have time to explain what that is to some of you, but went to Blockbuster Video and saw what videos he had rented. So the law that they passed back then was that you can't go and look and see what videos people have rented. And now that's been transformed to you can't look at what videos people have clicked on online in order to out them. So that's been part of it. In this last point, I know we're near the end of our time, involves just the need to include and collaborate with your marketing teams, because on my end of things, when we're talking to a client about their privacy regimen, I will ask all the questions about the data mapping, the protections. But at the end of the day, I said, let's talk to your marketing team and see where they're getting their leads and how they're going about their marketing, because invariably, that's a whole different ball of wax. So I leave this more as a question than an answer as we get to the end of our time here. But AI is going to continue to progress. It's hopefully going to continue to be a tool of ours. And if you combine that, I think, with the quantum computing that's coming, the world is going to change again significantly in about 10 years. And so in a way, what we're doing is writing the Constitution for the data-centric world that we're going to live in. And while there's good reason to be fearful, I think there's a lot of good reason to be optimistic. With that, I don't want to go past our time, so you can send us any questions that you have in writing or by text, or you can find our contact information. For those of you in Ohio who need CLE, this is the code that you will be asked to submit for Ohio CLE present. credit, 100-924. And then finally, here's some resources that you can find online as well that are QR codes that show some of the things we've published. And with that, we come to the end of our time. We thank you for being with us and hope this has provided you with some insights